come from the Center for Commercial Law Studies. I'm a reader in intellectual property and technology law, working so in terms of lecturing to postgraduate students who specialize in IP and technology, and working on various research projects with various bodies from WIPO, UK government, European Patent Office, private companies. Yes, working with the industry as well, to a large extent. So originality is a requirement, is one of the main thresholds for copyright law. And frankly, originality is not a requirement which is difficult to satisfy. It depends on the jurisdiction in question, but in most cases what you need to show is that it originated from you and it is the product of you exercising your discretion and making choices. The minute this is established, it means it originated from you, it's the product of you exercising this discretion and making choices, you've satisfied, and again, as a broad description, you should be okay with the requirement of originality. You have satisfied the originality requirement. Novelty is something that we have both in design, in registered design, also unregistered, where you have an unregistered design regime. I understand that that's not the case in Kenya, and in patent law. And there, it is what you need to show that this which you have created has not been there before. So it is novel, it is new. In the case of patent, it's not sufficient. First, you need to show that it's new. But even if it's new, it doesn't mean necessarily that it deserves patent protection. You have to show that you have more than that. Because sometimes something can be new, that is, nobody did it before, but if you would have asked somebody to come up with it, they would have done it fairly easily. In other words, it would have been obvious to do so. In patent law, you need to show also that it is not obvious to the person who specializes in this particular field. In our case, designing mobile apps. In order to have something registered as a trademark, you have to show that it is distinctive. Now, distinctive can either be inherent in the thing itself, so you have never seen, and nobody in the public has ever seen the thing before, but if I would show it to a member of the public, it is likely that if I would show it to a member of the public in relation to the product in the marketplace, they are likely to view it as an indication of origin, rather than being aesthetic, ornamental, functional, or just arbitrary. It's there because it's there. No, it's there in order to indicate origin. So that's one thing, that's inherent distinctiveness. But some things are not inherently distinctive, but become distinctive through use. In other words, we, the public, because we see it again and again in the marketplace, we are educated to view it after a while, because we've seen it again and again, as indicating a particular source of origin. That is acquired distinctiveness. That means that that person, our developer, would have to recreate the wheel again and again every time they embark upon a project. And this is why, in the vast majority of cases, people do not assign copyright in the case of such development projects. What you have is a license. You keep your copyright, but you provide the commissioning party with permission to use, under certain circumstances, what they paid for. Permission, in other words, that's a license. Now, what is the scope of that permission depend on the particulars of that agreement. So, is it just permission to use, but I, the developer, I am free to use it in any other context? Do I have some kind of a limitation, for example, in terms of sectors? Is there a limitation in terms of time? And the more limitations are imposed on me as a developer in reusing bits of my code, the more I should factor that into the price of the commission. And the more exclusive you, the commissioning party, want it to be, the more you should remunerate the developer, as a general rule of thumb. Yeah. So this is very fresh. I mean, it's fresh from the press, just a few weeks before Christmas, and that is a collaboration between Strathmore University and Queen Mary, the institution, my home institution, Queen Mary University of London Centre for Commercial Law Studies, and the idea is to establish a legal clinic for startups in the tech industry, where anyone who is interested in and wants to see how it works can go already now out and put Q Legal and see how it works in London. And this is a model that we exported to a couple of other universities. And I don't know, in terms of a timeline, I think it should take place so watch this space. It should take place so it's in the near future. And the idea is for developers, for entrepreneurs, designers and so on, the tech industry, to come and seek legal advice that they would be able to get for free from law students that specialize in those areas in Strathmore University. Those law students would be supervised by people with a higher degree of expertise in that particular field of specialization. And the idea is that everyone really gains. Our startup and developer people get legal advice for free. The student gets an experience of advising, getting their hands dirty with advising clients on real problem, not a problem question in an exam. And our entrepreneurs and senior lawyers get a chance to give back to the community by supervising those students. So it's a multi-layered model that now we have working for years in London. It's been extremely successful, and we are really excited of having a chance to work with Strathmore University here and giving any assistance necessary in order to establish such model here.